5 seconds to go. Start. The defense to show false recovery has been supported by the testimony of DW1 and DW2. Stop. The evidence regarding prior meeting of mind is not on record, thereby the appellant conspired or was a part of conspiracy in committing the loot and murder of the deceased. Stop. The connecting evidence regarding recovery of the record of the hotel has not been produced in original. Stop. Thus, merely on the basis of the said evidence and the recovery, which is not summarized in the FIR, the conviction of the appellant is wholly unsustainable. Stop. Para. On the other hand, the State Council contends that the amount recovered from the possession of the appellant as a sale proceed of the minibus has not been proved in support of his defense. Stop. The identification of the gold biscuits and looted articles were made by PW12, son of the deceased. Stop. In the defense, it has not been said that the gold articles seized were of the accused persons. Stop. No explanation for huge recovery of gold items has put forward from the accused, simultaneously Harpal Singh, to whom the minibus was sold, has not been examined, hence, the defense was not found plausible. Stop. On the other hand, looking to the testimony of PW1, PW2, PW4 and also the extrajudicial statement given by PW14, the High Court has rightly confirmed the findings of the trial court. Stop. Thus, the findings of fact concurrently recorded are based on due appreciation of evidence and those findings are not perverse. Stop. Para. After having heard learned counsel for the parties and on perusal of the record, it is seen that ample evidence to have conspiracy between all 5 accused have been duly proved. Stop. The involvement of the appellant is fully established by the testimony of PW14, who was an employee on the shop Sundar Shoes House. Stop. As per his testimony, it is clear that co-accused Ashwini Kumar, another employee in the shop, met with appellant accused on the shop at about 4:05 p.m. on 15th March 2000. Stop. At that time, deceased Banarsi Das was counting the cash currency at the counter. Stop. Ashwini Kumar told Harpal Singh that Banarsi Das was having ample money with him and he was also involved in the money lending business, keeping the gold as security. Stop. Subsequently, on the date of incident, that is 2nd April 2000, appellant along with co-accused visited the shop and made inquiry about co-accused Ashwini Kumar. Stop. Thus, by the evidence of this witness, nexus between appellant Harpal Singh and co-accused persons is fully established. Stop. The defense taken by the appellant regarding recovery of the cash money of rupees 2,84,000 from him by virtue of sale of minibus has not been proved because the said minibus was not sold to him and the buyer of the said minibus has not been examined. Stop. DW1 in his cross examination has categorically admitted that the amount was not lying in his bank account or of his father. Stop. Thus, the defense of the appellant was not found plausible. Stop. Simultaneously, no plausible defense to disprove other looted articles have been brought on record. Stop.